We'll hear argument today in Case 08205, Citizens United versus the Federal Election Commission. Mr. Olson.
Mr. Chief Justice, and may it please the Court, participation in the political process is the First Amendment's most fundamental guarantee. Yet that freedom is being smothered by one of the most complicated, expensive, and incomprehensible regulatory regimes ever invented by the administrative state. In the case that you consider today, it is a felony for a small, nonprofit corporation to offer interested viewers a 90-minute political documentary about a candidate for the nation's highest office that General Electric, National Public Radio, or George Soros may freely broadcast. Its film may be shown in theaters, sold on DVDs, transmitted for downloading on the Internet, and its message may be distributed in the form of a book. But its producers face 5 years in prison if they offer it in the home through the vehicle of video on demand. Because the limitation on speech, political speech, is at the core of the First Amendment, the government has a heavy burden to establish each application of a restriction on that form of speech is a narrowly tailored response to a compelling governmental interest. The government cannot prove, and has not attempted to prove, that a 90-minute documentary made available to people who choose affirmatively to receive it, opt in, by an ideologically oriented small corporation poses any threat of quid pro quo corruption or its appearance. Indeed, this documentary is the very definition of robust, uninhibited debate about a subject of intense political interest that the First Amendment is there to guarantee.
Mr. Olson, if the film were distributed by General Motors, would your argument be the same?
Well, it definitely would not be the same, because there are several aspects of the argument that we present. However, in one respect, it would. A 90-minute documentary was not the sort of thing that the BICRA, the Congress, was intended to prohibit. In fact, as the Reporters Committee for Freedom of Speech points out, the documentary is objectively indistinguishable from other news media commentary.
But the point then of similarity is you would, whether it was offered by General Motors or offered by this petitioner, in effect call for some qualification of the general rule allowing limitations on corporate political activity of the speech variety.
Yes, we would, although it is a very important factor.
How would we draw the line?
Well, one of the bases upon which you would draw the line is to look at the voluminous documentary record that the government cites, and this Court cited in the McConnell case, as a justification for the restrictions themselves.
Well, would every limitation on corporate speech or on corporate expenditure and the nature of speech be subject then to, in effect, this all-factor balancing test?
Well, I think what I'm trying to say is that what the Congress was concerned with, and Judge Cole-Arcatelli in the district court opinion that you considered in McConnell discusses this on page 646 of her opinion, that this sort of communication was not something that Congress intended to prohibit. You would look at, if Congress intended to prohibit 90 minutes.
So your argument then is there's something distinct about the speech which could be considered regardless of the corporate form.
Well, that's part of our argument, yes.
If that is the case, what is the answer to this? That still is going to involve a fairly complicated set of analyses, probably in a lot of cases. Why is that necessary or worthwhile to preserve First Amendment values when you could have done this with a PAC?
Well, as this Court said in the Wisconsin Right to Life case just a couple of years ago, that the PAC vehicle is burdensome and difficult.
That's right. You got reporting, you got limitations on corporate contributions and so on. But in this case, for example, most of your contributions, as I understand it from the record, were individual. They weren't corporate. There was one, perhaps. There was some corporate contribution.
Yes, on page 252 of the appendix and 251, it points out, you're absolutely correct, that 1% of the contributions were from corporations.
Was that established? I thought that the record was hardly made of the contributors to this film. I think there was something like $200,000 accounted for, and the film cost to get the Channel 08, whatever it was, to put it on, cost over $1 million.
The government sent an interrogatory, Justice Ginsburg, asking for the major contributions with respect to this project, and the ones that they sought, the government sought what they thought was important. The answer to that interrogatory is at page 251A and 252A, that the government was seeking information with respect to contributions at $1,000 or more. 198,000 came from individuals. And by the way, the three largest contributors that are listed on page 252 of the joint appendix are given credit in the film itself. So there's no effort to conceal those individuals. Okay. So that it's possible that corporations throughout America were giving small amounts of money to this. That record doesn't establish one way or the other. What it does establish is what the government felt was necessary for its case, that the major contributors were individuals and not corporations.
You answered Justice Souter. I took your answer to be the following, that if the corporation had paid for a program, and the program was 90 minutes, which said vote for Smith over and over, that's the program, that you concede that the government could ban this under the Act.
Well, it is difficult for...
I don't think they would. We agree it's an imaginary hypothetical. But in fact, if they did have 90 minutes of vote for Smith or vote against Jones, you concede, for purposes of this argument, that the government can ban it. Is that right or not?
If not by this organization, we think that if it's a small, nonprofit organization, which is very much like the Massachusetts...
Okay. So one of your arguments is this is a special corporation, you can't. Now suppose it's General Motors. Can they?
Well, General Motors may be smaller than the client that we're representing. I understand the question.
I want to get an answer to the question.
Yes, I think.
Yes,
that
okay.
To the extent
now,
that
then my question that I'm driving towards is, since General Motors can, in your view, be forbidden to have our film of 90 minutes, vote for Smith, vote for Smith, vote for Smith, or vote against Jones, vote against Jones, vote against Jones, how is this film, which I saw, it is not a musical comedy, how does this film vary from my example? And why does the variance make a difference?
The difference is it's exactly what the court was describing in Wisconsin Right to Life. It is it informs and educates, which is what the court said, the Chief Justice's opinion, the controlling opinion said was the mark of an issue communication. And as this court said...
Mr. Olson, I thought you conceded at least as I read your reply brief, that you were no longer saying this is about an issue unrelated to any election. I thought you said that this was a 90-minute movie concerning the qualifications, character, and fitness of a candidate for the nation's highest office. And that's just what Wisconsin Right to Life was not. It was not about the character, qualifications, and fitness of either of the senators.
What the court said in Wisconsin Right to Life was that the distinction between an issue advocacy and campaign advocacy dissolves upon practical application. This is exactly what the court was talking about there.
But didn't the court there say this is not about character, qualifications, and fitness?
Yes, it did, Justice Ginsburg. But what my point is that there isn't just two boxes in the world of communications about public issues, one box for so-called issues and one box for campaign advocacy. That's what I think the Court meant when it said, not just in Wisconsin Right to Life, but in earlier cases, that the distinction dissolves upon application.
But no matter how many boxes we have, doesn't this one fall into campaign advocacy? I mean, I've got the government's brief open at pages 18 and 19 with the quotations. She'll lie about anything. She's deceitful. She's ruthless, cunning, dishonest, do anything for power, will speak dishonestly, reckless, a congenital liar, sorely lacking in qualifications, not qualified as commander-in-chief. I mean, this sounds to me like campaign advocacy.
What the Court was talking about, and as Justice Clark-Catelli talked about, is broadcast advertising, these 10-minute, 10-second, 30-second, 60-second bursts of communication that are the influence in elections.
I want to get the answer to what I was asking.
But it seems to me the answer to Justice Breyer's question, this is a don't vote for Jones.
This is a long discussion of the record, qualifications, history, and conduct of someone who's in the political arena, a person who already holds public office, who now holds a different public office, who, yes, at that point, Justice Souter, was running for office. But the fact is that what could the individual as I said, the Reporters Committee for the Right to Life said this is indistinguishable from something that is on the public media every day, a long discussion. It might be, what you're suggesting is that unless it's somehow even-handed, unless it somehow says, which would be viewpoint discrimination or prevention of viewpoints, which is the safe harbor that the government has written into its so-called safe harbor, if you don't have a point of view, you can go ahead and
that isn't the suggestion. The suggestion I was trying to get to is we know you can't just say vote against Smith, vote against Smith, vote against Smith. Now, I wanted to know the difference between that and a film that picks out bad things that people did. No good ones, just bad ones the candidate did. And then we have another film that picks out just good things candidates do. And so candidates run films that show the good things they do. And then someone else shows the bad things they do. Now, why is that not the same as vote against Smith, though I grant you it's more intelligent, it's more informative, it's even better electioneering? So we're after electioneering. Why doesn't that fall within the forbidden category?
The government has the burden to prove there's a compelling governmental interest narrowly tailored, Justice Breyer, because all kinds of things of the type that you're talking about are permissible if your name is General Motors. I mean, if your name is General Electric rather than General Motors, if your name is Disney, if your name is George Soros, if your name is National Public Radio, what you're suggesting is that a long discussion of facts, record, history, interviews, documentation, and that sort of thing, if it's all negative, it can be prohibited and it's a felony. You can go to jail for 5 years for sharing that information with the American public. Or if it's all favorable, you can go to jail. But if you did half and half, you couldn't.
No, I guess it's the same as if you were to say, I think Smith is a great guy. That's all. I'm sharing information. And what I don't see is if you agree that we could ban the commercial that says, I see Smith is a great guy. Why is it any different to supplement that with the 5 best things that Smith ever did?
Because of the First Amendment. Congress shall make no law abridging the freedom of speech. When this Court has permitted that to happen, it has only done it in the most narrow circumstances for a compelling governmental interest.
But I guess what Justice Breyer is asking is, I have the same question. If we concede, and at the end of the day you might not concede this, but if we take this as a beginning point, that a short 30-second, 1-minute campaign ad can be regulated, you want me to write an opinion and say, well, if it's 90 minutes, then that's different. It seems to me that you can make the argument that the 90 minutes is much more powerful in support or in opposition to a candidate. That's the thrust of the questioning.
I understand that, Justice Kennedy, and it is difficult. But let me say that the record that you were considering at McConnell, and I specifically invite, as I did before, the Court's attention to 646 of the District Court's opinion, which specifically said the government and Congress was concerned about these short, punchy ads that you had no choice about seeing, and not concerned about thorough recitation of facts or things that you would have to make an affirmative decision to opt into. And the reason why it's difficult is that we are talking about an infinite variety of ability of people to speak about things that matter more to them than anything else. Who will be
Counsel,
president?
I think you've kind of shifted your focus here from the difference between a 10-second ad and a 90-minute presentation and how that presentation is received, whether it's over the normal airwaves or on this video on demand. What is the distinction between the 10-second commercial and, say, the 90-minute infomercial?
The thing that I think it's pointed out specifically in your opinion, controlling opinion for Wisconsin right to life, that which informs and educates and may seek to persuade is something that is on the line of being permissible. The government hasn't established, never did try to establish. I didn't shift, but all of these are factors. It's who's doing the speaking.
You can educate in 30 seconds. I mean, in a 30-second ad, you present just one of these criticisms of the candidate instead of lumping all of them together for 90 minutes.
The point, I think,
that educate?
The point, I think, Justice Scalia, is yes, you can educate in 10 seconds, you can educate in 30 seconds, but what the Court was trying to do, what Congress was trying to do, is get at the things that were most potentially corruptive.
Are you making a statutory argument now or a constitutional argument? What Congress was trying to do has nothing to do, it seems to me, with the constitutional point you're arguing.
The government makes the point that it established a voluminous record of evidence. Both Congress had before it and this Court had before it a voluminous volume of evidence because it had the burden of proving that something was really bad with these types of advertisements. And what the Court did is say, well, okay, in McConnell, yes, there is a substantial burden that the government met that these types of communications, not the Internet, not books, not other types of things, are really bad enough that the government could pick those out, and it is narrowly tailored its solution to that problem by prohibiting those things. And the government talks about this today in its brief, the things that Congress felt were the most acute problem.
So you are making a statutory argument now. You're saying that this isn't covered by it.
Yes, I am making a statutory argument in the sense that you will construe this statute in the ways that doesn't violate the Constitution. The Constitution, as the Court said in Wisconsin Right to Life, gives ties to the speaker, errs on the side of permitting the speech, not prohibiting the speech, and so all of those things may be statutory arguments, Justice Scalia, but they are also constitutional arguments. And in response to every one of these questions, the government has the burden of proving this sort of speech, which the reporters say is indistinguishable than the kind of information that news media puts out all the time.
So this argument doesn't depend upon whether this is properly characterized as the functional equivalent of express advocacy. Your contention is that even if it is, that because it wasn't in the factual record in McConnell or before Congress, it is a type of express advocacy that's not covered by the Act?
I don't think, Chief Justice Roberts, that it is remotely the functional equivalent of express advocacy, because what the Court and Congress was thinking about with respect to express advocacy was short, punchy.
Well, that's what I'm trying to figure out, the distinction in your argument. I mean, if we think that this is the functional equivalent of express advocacy, are you contending that it is nonetheless not covered in light of the record before the Court in McConnell and before Congress?
I think I would agree with that, but I would also say that the idea, functional equivalent of express advocacy, is the very magic word problem that this Court has struggled with in McConnell and in each of the cases. I said at the beginning that this is an incomprehensible prohibition, and I think that's demonstrated by the fact that since 2003, this Court has issued something close to 500 pages of opinions interpreting and trying to apply the First Amendment to federal election law, and I counted 22 separate opinions from the justices of this Court attempting to, in just the last 6 years, attempting to figure out what this statute means, how it can be interpreted. In fact,
well, that's because it's mandatory appellate jurisdiction. I mean, we don't have a choice.
There would be fewer opinions. I guess my point is
maybe
that
those cases presented more difficult issues than this one.
I think this presents a much easier issue, Justice Stevens, because this is the type of – if there is anything that the First Amendment is intended to protect in the context of elections that are occurring, which, by the way, occur 4 years running, but the last election, presidential election, occurred throughout the entire 2008. If the American people need to have that kind of information. And the statute is both overly broad, because if it was a hotel ad, if it was a hotel saying Senator Clinton stayed here or Senator McCain stayed here, it would be prohibited because it was a hotel saying so, even though it really had nothing to do with the election. If it is if it's a corporation that put together an analysis of the earmark positions of each of the senatorial candidates. So most of all of the candidates were running from the Senate. They all had these issues where they may have voted or not against earmarks.
But, Mr. Olson, this is – I think you were right in conceding at the beginning this is not like the speech involved in Wisconsin Right to Life. This is targeted to a specific candidate for a specific office to be shown on a channel that says Election 08. That tells the viewer over and over again what, just for example, it concludes with, these are things worth remembering before you go in potentially to vote for Hillary Clinton. Now, if that isn't an appeal to voters, I can't imagine what is.
Yes, Justice Ginsburg, I understand your point. There is much in there that if you saw it, you would form an opinion with respect to how you might want to vote. You might form all kinds of different opinions. But it was an analysis of the background, record, and history and qualifications of someone running for president. Of course I concede that. But what is the maker of a movie to take out in order to prevent that from happening? I understand from some of the questions that it was more even-handed. If it said, well, this candidate did this, but this candidate did this, or this candidate was born in the Panama Canal Zone and this candidate was born in Hawaii, and that affects whether or not they're natural-born citizens or not, and it was more even-handed, would that then not be a felony?
Well, as you said yourself, as you pointed out, there is a point at which there is no non-porous border between issue discussion and candidate discussion. But I think the problem that Justice Ginsburg is having, that I'm having, and others, is that it does not seem to me that with the quotations we're dealing with here, as Justice Breyer said, it's not a musical comedy. I think we have no choice, really, but to say this is not issue advocacy, this is express advocacy saying don't vote for this person. And if that is a fair characterization, the difference between 90 minutes and 1 minute, either for statutory purposes or constitutional purposes, is a distinction that I just cannot follow.
Well, it is a distinction that Congress was concerned about, and it's a distinction that's all over the record.
But you say that. Why? What is your basis for saying that Congress is less concerned with 90 minutes of don't vote for Clinton than it was with 60 seconds of don't vote?
Because the record in Congress and the record in this Court is that those types of advertisements were more effective because they came into
They are the characteristic advertisement. There is no question about that. That is the paradigm case. I agree with you. But I don't see how you then leap from saying that is the paradigm case to saying that this never covers anything but the paradigm case when the only distinction is time.
I think what Congress was concerned about is the most severe and the most acute problem, as Justice Kolar-Catelli said, which everyone acknowledges was the problem Congress sought to address with BICRA. It's not just that, however. The point that you just made about a non-porous border, it is the government's responsibility, to the extent that you can't figure out how even-handed you must be or what you must take out of your communication in order not to go to jail for airing it. It is the functional equivalent. If everything is the functional equivalent, it mentions a candidate during an election, which is what the government says. It's the functional equivalent of a prior restraint.
Mr. Olson, I think we've been led astray by the constant reference to what Congress intended. As I understood your point, it was not that one is covered by the statute and the other isn't, but it is that one is covered by the Constitution and the other isn't. And it may well be that the kind of speech that is reflected in a serious 90-minute documentary is entitled to a greater constitutional protection. And it may well be that the kind of speech that is not only offered but invited by the listener is entitled to heightened First Amendment scrutiny, which is what this is, since you had to pay for view.
I agree with that completely, Justice Scalia. Mr. Chief Justice, if I may reserve the remainder of my time.
Thank you, counsel. Mr. Stewart.
Mr. Chief Justice, and may it please the Court, the lead opinion in Wisconsin Right to Life didn't just use the term functional equivalent of express advocacy. It explained what that term meant. And on page 2667 of volume 127 of the Supreme Court Reporter, the plurality or the lead opinion stated, in light of these considerations, a court should find that an ad is the functional equivalent of express advocacy only if the ad is susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate. So the functional equivalence test doesn't depend on the length of the advertisement or the medium in which the advertisement
Well, the length of the advertisements wasn't remotely at issue in either Washington Right to Life or McConnell or before Congress when they passed this law.
Well, certainly Congress considered a variety of evidence bearing on campaign practices that had been undertaken in the past. They were primarily — most of the examples on which they focused were 30-second and 60-second advertisements. It's certainly been a recurring phenomenon in the past that candidates would air, for instance, 30-minute infomercials.
Any discussion in either McConnell, any citation either in McConnell or the congressional record to those types of documentaries?
I'm not sure about the citation, and I'm not aware of any citation in McConnell or the congressional record, but it was certainly a known phenomenon. And I think the real key —
Well, I mean, how do we know it was a known phenomenon in terms of the evolution of the statute and the decision of this Court upholding it?
Well,
There's no reference to it.
I think the real key to ascertaining Congress's intent is to look to the definition of electioneering communication that Congress enacted into the statute. And that definition requires that the communication be a broadcast, cable, or satellite communication in order to qualify as an electioneering communication, and that it be aired within a certain proximity to a federal election, and that in the case of an election.
So if Walmart airs an advertisement that says we have candidate action figures for sale, come buy them, that counts as an electioneering communication?
If it's aired in the right place at the right time, that would be covered. Now, under this Court's decision in Wisconsin Right to Life, it would be unconstitutional as applied to those advertisements, because those advertisements certainly would be susceptible of a reasonable construction.
Do you think the Constitution required Congress to draw the line where it did, limiting this to broadcast, cable, and so forth? What's your answer to Mr. Olson's point that there isn't any constitutional difference between the distribution of this movie on video demand and providing access on the Internet, providing DVDs either through a commercial service or maybe in a public library, providing the same thing in a book. Would the Constitution permit the restriction of all of those as well?
I think the Constitution